helpful to others as well. Okay, so there we go. We have now started the recording. This is in relation to the Week 9 topic on Wednesbury and reasonableness and the outer limits of legality, which is our Week 9 topic. And we've devoted the first 10 minutes of 10 minutes before the tutorial as a drop-in session. Of course, we've started about 3 minutes early. So, you know, if you happen to have any questions, feel free to raise them. Otherwise, I'm just going to hang around. The recording. Okay, go on. Marcus, go on.
With the submission in Moodle, how do you want it saved with the group names? I mean, with Constitutional, you wanted when we had a group, you wanted
yeah,
sort of one name underscore another name. Do you have a preference?
No, I'm not very particular at this point with the file name, mainly because a lot of students tend to forget the instructions for that. So that's not important to me. What is important though is that if it's going to be a, you know, case notes that you're submitting as part of a group, I would like the names of all the group members to be placed in the document. So I don't have to look up who the members of the group are.
Yep.
That would be very important to me. I mean, I would know if it's going to be a group submission because there will be more than 3 case notes. But unless I know the names, then I'll have to end up, you know, having to look for my Excel file, and you know that adds an extra complexity to what could have been a very easy task. So I would appreciate, you know, the student members of a group putting in all the names of the members of the group in the document.
Okay, thank you.
Welcome.
Sorry, Manjo, it's Emma.
Yes.
Just want to clarify, we don't need to actually identify which case note each group member did though, do we?
No.
Okay, excellent, thank you.
Yeah, thanks for the question. You don't need to identify the, you know, who did what, because essentially, as I already initially pointed out, if it's going to be group work, you are all going to have the same mark as part of the group. Are we clear on that? So all the members of a group will have the same mark for the assessments, whether it's for the video presentation or the case notes. So that's the thing. And I mean, there was always the opportunity for students to do the assessment on their own. So if they decided to do it as a group, then they will all end up with the same group. But of course, I would imagine that the quality of a group assessment, assuming that the members actually worked together as a group and, you know, met and reviewed each other's work, will definitely be much better than a work that was done by just a single individual. Mainly because, you know, with more people thinking about how to write things, providing their comments about what might be the crucial facts in a case, identifying the legal issue and identifying the rules and so on, the output certainly has got to be better. Now, I'm not saying that those who are doing things on their own will necessarily end up with inferior work. That's not what I'm saying. But we probably know that people who are able to work harmoniously as a group tend to do better. Questions? Hello, Yomi. Questions, comments? Now, I've noticed that some of you don't seem to have your names. It'll be very helpful. Okay, so hang on. So which one is Ash here? So Ash has turned her video off. I remember Emma, Jess. Not sure remember how Jess looks. Marcus, Peter, of course, I know her. Peter, Yomi, Sarah. Oh, there's Sarah. Okay, very good. So it's always good to be able to put names to faces. Questions, comments?
I'll be glad when the school holidays are over. That's my comment today.
Yeah, so that's true. I'm not really sure if that's necessarily a bad thing, especially because, well, so in my case, I share custody over my 6-year-old daughter with my ex-wife, and under the court order, I actually have my daughter with me twice a week. Yeah, 2 times a week in a fortnight. And what then happens is that because I mainly work from home, she gets dropped off at my house during the day, which means that I get to actually see her. That works quite well when the school days are there, because all I need to do would then be to, take care of her before bringing her to school, and then I pick her up from school, then she stays with me until she gets picked up. But otherwise, I end up working like at a...
That would probably help.
What was that? So otherwise, I end up kind of working in a daycare center environment where I have to watch over my 6-year-old daughter full time throughout the day. But otherwise, but that's the thing about happiness. For example, we had that discussion in our Happiness for Learning workshop. When you talk about happiness, there's one on the one hand, you can define it in the sense of a pleasurable experience, like you're being excited, the feelings are very positive, and yet it's not easy to be taking care of kids, as I think a lot of you, for those of you who've got kids, are aware of. And so then, but it's meaningful, although it's not necessarily pleasurable. So yeah. But a lot of studies have actually asked that question among parents, and it's confusing because when parents are asked the question, "Are you happy to have kids?" And then they would say that it's not really pleasurable to be taking care of children. And for those, as I said, who are parents, that can be understandable, especially when children end up having tantrums. They make so many unreasonable demands, which to them might be reasonable, but are unreasonable to us. So it can make the experience, in a sense, unpleasant. But then again, at the end of the day, you find meaning in doing it. And I guess in terms of relating it to the idea about love, it's not so much about what you gain out of the experience, but whether or not you make another person happy. And if you do, you're that makes you happy. So, but it does disrupt doing assignments, absolutely. It's not easy. Yeah, and it does build character. True. I mean, being patient with kids. Okay. So there's Rob. There are now 14 of you. I'm glad that we've got 14 students tonight, and I'm more than sure that there'll be others coming in a few minutes, despite the fact that we have a major assessment due tomorrow. So that's a good thing. So we now have Simon, we have Dakota. So we still have 4 more minutes before we start the tutorial. Would there be any other questions you might have? Anything that's unclear? Okay, so none. So we'll just stay on, and then we'll start exactly at 7, because otherwise we might have students who complain why we start early. And then they'd say that, they may have missed important things, although it's recorded, but still, we're just going to give them an opportunity to actually be there when we start exactly at 7 o'clock.
Hi, Manjo, it's Gay. If we've got time to fill, would you just mind with the peer review, it's probably written down somewhere that I haven't read, just like the due date and those sorts of things for the peer review. Obviously, we can't start until everyone's submitted, and so it's not something I should worry about tonight. But I imagine we'll all get started on that next week. And when do you expect we all submit our peer review?
I think I indicated in an email that they should be returned to me 2 days before the return date that I promised. I don't have it with me now, but it might have been on February 2 that I promised to return your marked assessments, if I remember correctly. And if that is the case, meaning 2 weeks from now, it will have to mean that you need to return the peer assessment review and marks on the 31st. Now, don't quote me on that at this point, because I can't really remember. I do know that it is 2 days before the promised return date, which I indicated in the unit profile. So was that going to be what exactly is February 1, 2018, Leonie? Was that when I was going to return your marked papers, or?
Well, you've got two here. You've got due dates the 31st of January at the top in the peer marking assessment section of Moodle, and then down the bottom where you actually submit it and it says submission status, you've got Thursday the 1st at 12:55 a.m. Whereas up the top it says 31st of January, Wednesday at 11:55 p.m.
Yeah, let me just look up, let me just check the unit profile now, because that's probably going to be more reliable. So according to the unit profile, I promised to return your marks on February 2, which is a Friday. And so I'm more than certain that in the instructions I gave, I need to get the peer marks and reviews on the 31st. So they should be returned to me on the 31st. Okay, so we could probably start now. What I'm going to do is I will mute everyone, and because I'm picking up some background noise. And in the event you wish to say something, feel free to turn on your mic or call my attention by chatting, and I'll try to pay attention to the chat that goes on. Okay, so tonight we will talk about Wednesbury reasonableness and the outer limits of legality. Now, what we need to remember, and this is a very crucial point, is that as far as judicial review is concerned, we recall that judicial review is concerned with courts trying to review the legality of administrative or executive decisions. It's all about the lawfulness of executive decisions. Now remember, because I saw some comments in Facebook where, you know, I think some were quite uncertain whether executive or administrative are one and the same thing. They are, for our purposes. So when we speak of executive, we also mean administrative, meaning as opposed to the judiciary or the legislative branches of government. So we really, as I said, as far as judicial review is concerned, it's concerned with the questions about the legality of administrative or executive decisions. And as far as merits review is concerned, it focuses not only on the factual correctness of decisions, but also whether or not, you know, the exercise of discretion is the preferable one. So the merits review by administrative tribunals, such as the Administrative Appeals Tribunal, would be concerned with what is known as merits review, which focuses really on the facts, you know, the correctness of facts, but also about the proper exercise of discretion. Now, as we know, therefore, as far as judicial review is concerned, the factual review of executive decisions is meant to be off limits to the judiciary. So let me repeat. Generally speaking, the factual review of executive decisions is off limits to the judiciary, mainly because of the concern of the courts that they may tread into what are clearly demarcated as belonging to the executive. So courts exercising judicial review are meant to avoid reviewing the factual correctness of executive decisions. So are we clear about that? So in Australian law, there is a clear demarcation between legality and merits, as I've explained. Now, the tricky thing here is that when we look at the idea of Wednesbury unreasonableness, we get the sense that somehow the idea about Wednesbury unreasonableness does intrude into the distinction between law and facts. So in other words, Wednesbury unreasonableness becomes an instance when courts somehow actually review the facts. My daughter tonight. So sorry about that. So judicial review, when Wednesbury unreasonableness becomes the ground for review, it becomes an instance when courts somehow begin to examine the facts pertaining to the executive, to the decisions made by the executive. And So what we're going to do tonight, therefore, is to examine those instances when this is so. So in other words, even when we speak about the legality versus merits distinction, it is not very cut and dry. It is actually more complex than it seems. So we have to be very aware of that, because the idea of Wednesbury and reasonableness as a ground for judicial review, both under the ADJR Act of 1977 Commonwealth as well as under the common law, would actually entail, in a sense, a review by the judiciary of the facts as determined by administrative decision makers. So having said that, after studying this topic, you should be able to discuss and explain unreasonableness, illogicality, and irrationality as grounds of judicial review. And in relation to that, we wish to determine what exactly does it mean when a decision appears to be unreasonable, and how is that different from being irrational. So could it be said, for example, that a decision might appear to be rational but unreasonable, in the sense that if a decision is rational, it means there's a reason behind it, right? And yet, does it mean that despite there being a reason, it becomes unreasonable? So are they one and the same? And we will talk about requirements to establish unreasonableness as a ground of judicial review, and fraud and bad faith as grounds of judicial review. And for the purpose of going through this particular topic about Wednesbury and reasonableness, which if I remember correctly, will be one of the areas to be covered in the final assessment, we will go through 5 discussion questions tonight, beginning with this one. Can I get somebody to volunteer to read problem 1 for us, please? Just to read it.
I will, Manjo.
Thank you.
Cornelius James, as senior manager of the Department of Social Services, DSS, was fired from his job after the DSS investigated panel, DSS IP, found him to have committed sexual harassment against Jill Lockworth, his subordinate. The disciplinary proceeding against Mr. James had been based on the Public Sector Ethical Standards Act, Commonwealth, which prohibits sexual harassment. Mr. James asserts that the penalty of dismissal that was imposed is totally unreasonable and irrational, considering that he had been in government service for more than 20 years, always had sterling performance reviews, and was at no time the subject of any disciplinary action or investigation. Given that it was open to the DSSIP to impose a penalty such as a suspension, it was totally unreasonable and irrational for it to have imposed a penalty of dismissal. Advise Mr. James on whether the decision met the Wednesbury reasonableness standard of judicial review.
Thank you, Yomi.
Oh, Wednesbury, sorry.
Actually, I got corrected by some students in the past that it's meant to be pronounced as Wednesbury.
Oh, Wednesbury. Okay, it's a silent D. Okay.
Yeah, like Wednesday.
Wednesbury.
I'm pretty sure. I mean, I was, told by students, well, probably in the UK. And, because that's a UK case, so they said it's meant to be pronounced as Wednesbury. So I kind of adopted that now. Okay. What do you think? So if you were to be the lawyer or the solicitor, would you advise Mr. James to apply for judicial review or not? So can I just get you to answer in the chat box initially, whether or not, say apply or do not apply? Should he apply?
Can I
Yes.
just clarify, Manjo? It's Monique. Sorry. Now, it says that it was open to the DSSIP to impose a penalty such as a suspension. Was the penalty of dismissal available or not? I just want to clarify that.
It certainly was. It was.
Okay, thanks.
So we're just saying that, it was the DSS had within it the range of potential penalties, including, you know, from suspension all the way to dismissal, and that they chose dismissal. So we've got some answers here. Do not apply. Do not apply. A lot of students said do not apply. Okay. Can somebody take the floor to try to explain why you believe that you should advise Mr. James not to apply for judicial review?
Is it because they were working within the statutory power of the Ethical Standards Act?
Okay.
Hang on, no, I've got that backwards. Hang on, wait.
Who was that? Who was that?
Sorry, that's Leonie. Hang on, wait. I'm going to come back to that. Sorry.
There was something there in what you said. You gave up too soon.
Oh, no.
Yeah. What did the other
I would say that because it was open to the panel to impose the penalty of dismissal, and he had acted against the the Ethical Standards Act, then, you know, it might have been a little harsh, but I wouldn't have said it was unreasonable to the extent of Wednesbury unreasonableness.
That would be the correct answer. So that would be the correct answer. In fact, thank you, Monique. So the answer is correct, as stated by Monique. So if you look at the cases pertaining to the idea about the unreasonableness of a decision, the High Court has often said that it's a very high standard to be met. So it's one thing for a lawyer to claim that the decision is unreasonable, and being unreasonable can mean a lot of things. It could be that, you know, you don't really agree with the decision, therefore it's unreasonable. But for a decision for a decision, for example, to be decided by the courts as being unlawful and meeting the Wednesbury unreasonable standard, the requirement is that it must be such a decision that no reasonable person could have arrived at such a decision. So in other words, if it is, as pointed out by Monique, if it is actually open to the DSS IP panel or the DSSI panel to arrive at a decision of dismissal under the facts, meaning, you know, we could say that out of 20 individuals, sensible persons, some will say you should just suspend, but others will say, you know, we should just dismiss. It's actually open to any of those sensible persons. Then it can be said that such a decision will not meet the standard of Wednesbury unreasonableness. So the answer here is that, as a lawyer, as pointed out by Monique, you should advise Mr. James against applying for judicial review on the ground of Wednesbury unreasonableness, because it was actually open to the DSSIP to meet the penalty of dismissal rather than a penalty such as suspension. Very good. So that was easy.
Excuse me, Manjo. If something like this was in a final paper, could I please ask a huge favour? Where I had to clarify that dismissal was also open as an option for the panel, could you be more specific in your questions? That's the sort of thing I'd look at and I'd go, oh my God, I need to ask this question. And I'd rather not make an assumption, because if you assumed that it wasn't, then you'd have the wrong answer. You know what I mean?
Okay, so it was a bit vague.
Just a touch.
Right, you're right. Okay, very good. I'll keep that in mind. Very good. So the way it should have been written, given that it was, maybe you could say it was also open to the DSSIP to impose a penalty such as suspension, apart from dismissal. So maybe something like that.
Yeah, because otherwise I'd assume that if it wasn't written,
Right.
I'd assume that perhaps they didn't have that option.
Very good, very good. Okay.
Thank you.
Manjo, it's Peter here.
Peter.
I'd like to just ask why you wouldn't regard this as capricious use of power, which is a category of unreasonableness, because the facts of the case actually seem to marry in with the Edelston case, in that he was they had a choice of penalties, and he could choose, from which to choose from, and they chose the harshest one.
That's right. I would find it, from my point of view, I would find it difficult to assert that this decision actually meets the level of Wednesbury unreasonableness, mainly because so this is different from the case of Edelston versus Wilcox, as we will shortly see. And I'm going to bring up another problem in a short while, because I think generally we could agree that it was really open to the DSSIP to actually issue dismissal as a penalty because of the severity of the actions of Mr. James, which involves sexual harassment. So this isn't a minor event of maybe, making a sexual joke or, a light touch. This is sexual harassment, which I think a lot of you will agree appears to be a grave offense. So for that reason, given the severity of the action of sexual harassment, I think reasonable persons may disagree, but it is certainly open to reasonable persons to say that the penalty of dismissal is actually the appropriate penalty, given that the offense is one involving sexual harassment. Now, as I said, if the charge against Mr. James had been one about, cracking a joke, probably touching, what's her name, Jill Luckworth on the arm with some sexual overtones or overtures, maybe it can be possible to argue that, dismissal is not warranted, and if dismissal were to be given under the circumstances, it would then involve a capricious use of power. But this involves sexual harassment. So I think if I were to be marking this, I will not accept an argument that this involves a capricious use of power, because you would have to argue why it is unlikely for sensible persons to disagree that dismissal is an appropriate penalty. You would have to argue in your application of the law to the facts that the only appropriate penalty should, in all instances, should be suspension, notwithstanding the fact that the offense is actually one that involves sexual harassment, which is a very severe offense.
So you need to look at the offence as well as what the penalty was.
Certainly have to, yes.
And yeah, okay, no, that's fine.
The case law will tell you that a lot of it involves the context. So you cannot, just base it on the legal principles involved. Everything is actually context dependent. So if the context had been different, maybe, but this is something else. This is sexual harassment. Now, I'll give another example, because this is a crucial point that Peter raised. Let's go to problem 5. This is a slight variation of the problem. Can I get somebody to read problem 5 for us?
I'll read it.
Thank you.
Alfred Monks, a clerk of the Department of Social Services, DSS, was fired from his job after the DSS investigation panel found him to have stolen stationery in the amount of $20. The disciplinary proceeding against Mr. James had been based on the Public Sector Ethical Standards Act of the Commonwealth, which prohibits theft. Mr. Monks asserts that the penalty of dismissal that was imposed is totally unreasonable and irrational, considering that he had been in government service for more than 20 years, always had sterling performance reviews, and was at no time the subject of any disciplinary action or investigation, given that it was not open to the DSSIP to impose a penalty, such as a reprimand or suspension. It was totally unreasonable and irrational for it to have been imposed a penalty of dismissal. Advise Mr. James on whether the decision met the Wednesbury unreasonableness standard of judicial review.
Thank you. So there you go, different context. What do you think? Thank you, Curtly.
This one's going to be a real hard one for me, Manjo, because I used to work for the Commonwealth Bank, and we had a couple of guys who were actually sacked because the bank owed them tea money in those, meal money, and which they were supposed to have been paid the day after they worked, they accrued it. Okay. And it wasn't paid for about a week, and these guys were sacked, and the union took it to court, and the court upheld the bank's decision to sack them on the grounds that there was no degrees of honesty.
Very okay. Very good, Peter. Thanks for that context. Let me just provide another context, because this happened in the Philippines, which is the country I came from, although I haven't been back in the past 10 years. So just recently, about 2 weeks ago, there was an employee who was working in a supermarket who became so hungry, he decided to, grab a can of sardines. There are sardines, right? Cans of sardines being sold in Australia, right? So he got a can of sardines, and he took them to he was actually in the warehouse, and he opened it because he was so hungry, and it had gone past lunchtime. I think it was about 3 p.m. So he decided to eat it. Now, a can of sardines should be worth less than $1. Okay? So what had happened was that he was caught opening, the can of sardines and eating from it, and subsequently he was brought to the police station, where he languished in jail for 3 weeks. And it took, a series of social media complaints from citizens before the supermarket was embarrassed enough to let the guy go, but not before posting a bond of, let's say, $100. Isn't that ridiculous? So let me go to this, and I'll address Peter's example. My view here, following Edelston versus Wilcox, which was the case that Peter cited earlier, this would involve an instance where the exercise of power was capricious or oppressive. This is just, what was stolen was $20, and then you dismiss somebody? How can that be reasonable? That's a capricious, oppressive exercise of power, and the example there is the case of Edelston versus Wilcox. Now, I'm not sure I agree that theft is theft. A theft of $1 is not the same as a theft of $1 million. And courts do recognize the difference there. So they're likely to, even the police officers, I would imagine, unless we have a police officer here, are unlikely to prosecute somebody who stole $1 worth of goods and let him off with a warning. But somebody who steals something worth $10,000, that person's going to get hit. So I wouldn't agree that theft is theft. There are gradations, and I think the criminal laws will show that courts have it in their discretion to apply the proper penalty. Now, it would be different, murder is murder, right? So do you make a distinction between killing one person versus killing 100? Now, that's totally different here, okay? We're not talking about that. We're talking of theft of property. And if you follow the case of Edelston versus Wilcox, this is an example of a case where the courts are likely to say that it is when it meets the standards of Wednesbury reasonableness for somebody who stole, assuming it is true, who stole stationery in the amount of $20, to be meted the penalty, the extreme penalty of dismissal. Okay, so If you therefore distinguish problem 1 from problem 5, you will notice that the penalty ultimately, and whether or not a determination of whether the penalty is reasonable or unreasonable, Wednesbury unreasonable or not, depends a lot on the context. So the context here is, we're talking of the stationery amounting to $20 having been stolen. Now, let's talk about the bank. The first thing we need to remember is that laws pertaining to civil laws will have to be different from administrative law. Okay, so there is likely to be a different set of rules pertaining to the operations of private companies, especially banks. And it might be that in their code of conduct, theft is theft, and if you end up stealing something, then you could get sacked, perhaps. But I would argue that if somebody were dismissed for stealing stationery worth $20, I would imagine that that person will probably be able to argue before a judge that not in an administrative law case, but in a regular labor, in a regular employment case, that the penalty of dismissal would be too harsh. So I'm not really sure what the context would be in the scenario that Peter gave of a bank. So again, a lot of it depends on the context. So from Peter, it's very hard. I've seen small episodes of get off with a slap on the wrist. Yeah, that's right. So it all depends. In fact, if I were the manager and I caught somebody stealing $20 worth of stationery, would it even be worth my trouble to actually bring a disciplinary action case against that person? Right? I'd probably just give him a warning. In the same way, and this is a crucial point. Let's assume that a student is caught committing plagiarism. Okay, so in CQ Uni, let's assume, I'm changing the facts a bit, that a student is caught having committed plagiarism. Now remember that CQ Uni is a creation of a Queensland Act. So, and what had happened was that there was plagiarism because the student failed to properly reference the case notes. No, not the, okay, something in the case notes which would have required that, that student should have cited maybe the author of a journal that student was citing. And so therefore, the student committed plagiarism, but that involved a single, one sentence of failure to reference properly, which amounts to plagiarism. The question is, assuming that a disciplinary action were taken against the student, do you suppose that the university will dismiss the student? Or in the first place, is it likely going to happen that a disciplinary action will be taken against the student? So you see what I mean? It all depends on the context. So there are distinctions between minor plagiarism as opposed to major plagiarism. If it's a major one, perhaps dismissal as a student or expulsion as a student is open, but if it's minor plagiarism, the student is likely going to just be warned off, if at all. Or perhaps the student will just be told that next time, just take a course on referencing and so on. Okay. Now, for exam questions, make it straightforward and not up for debate. Which one is that? Like examples like this, Simon? Is that what you're saying? Like they're not too clear cut?
Yeah, just make them very clear cut. Like, maybe he rocked up to work late and they sacked him because he rocked up to work late.
No, that's actually the thing. I will never do that because cases are never clear cut. That's the thing. So what I'd rather happen is, so remember, when you answer case problems, you're meant to follow the IRAC format. Identify the issue, articulate the rules, and then apply the rules to the facts. So actually, it is possible for a student to argue, arrive at a conclusion that is contrary to what everybody else is thinking. And I'd be happy to examine the reasoning. how are the rules applied to the facts? So in the end, that's what lawyers are. That's what we lawyers do. We need to be able to argue a case. Otherwise, there's no role for lawyers here. So the argumentation will actually will actually come in the application of the error format. So, but if you're gonna, as a lawyer, for example, you're gonna argue that dismissal is the proper penalty for somebody who stole $20. It will take a lot of convincing for you to convince me that $20 is worthy of dismissal. I'd really be impressed with the reasoning that comes with it. So what you'll be confronted with will be not always, but there will be some scenarios where it's purposely meant to make you think, because otherwise, I mean, the important thing is, once you know the law, I'd like you to think about the law and whether how you apply the law to the facts in order to arrive at a conclusion. So it's unlikely to going to be clear cut, because if you examine a lot of the case law, it might even be possible to argue sometimes. So the courts, in many cases, appear to end up with contradictory decisions. But again, depending on the context involved, because it's never very clear cut. Sometimes it will be argued that there's Wednesbury unreasonableness. In others, you might say there isn't. And ultimately, it's all about the context and the reasoning, behind the decisions. Okay, so let's move on. We're going to go back to problem 2. Can I get somebody to read problem 2 for us?
I'll do it, Manjo.
Thank you.
After finishing a Diploma of Community Services work at the Goodness Good Technical Institute, Sherlock Gordon applied for a social support worker's licence with the Australian Department of Social Services, DSS. The Social Support Workers Act Commonwealth requires anyone seeking to practice as a social support worker to obtain a licence from the DSS and to meet requirements as to moral fitness. Gordon submitted all the requirements, including a police clearance that stated he has no record of any criminal conviction. The DSS, however, received an anonymous call saying that Gordon had been the subject of a police investigation for child molestation in 2005. That investigation had even been covered in the news at the time. Because of the unwillingness of any witnesses to come forward, the investigation had subsequently been terminated. Gordon was later informed by the DSS that it had concerns about his moral fitness because of the complaint against him for child molestation in 2005, and hence could not issue him a social support worker's licence. He has come to you as a solicitor for advice. Advise Gordon on whether he can apply for judicial review on the ground that the DSS decision was unreasonable.
Thank you, Leonie. What do you think? Was it unreasonable or not? And when I say unreasonable, I'm talking in the context of Wednesbury unreasonableness or under the ADJR Act.
I think the decision was reasonable. I think that based on the severity of the allegations in a social services context, I feel that the DSS would be, I can't think of the word because the movie is playing in the background, sorry. I think that they would really have some explaining to do if they had granted him a licence and something came out at the end of the day that there was this allegation. So I think it's reasonable just from that perspective.
Okay.
I totally agree with Monique on that one.
I would agree with Monique as well and Peter. So based on the context of the facts, it was open to the DSS to consider the fact that there was a police investigation for child molestation. It was even covered in the news. So even if the case may have been dismissed, because it was dismissed, right? According to the facts that I wrote there. Yeah, it had been subsequently terminated. It had subsequently been terminated. The fact remains that he had been under the shadow of doubt. He was under a cloud. possibly engaging in child molestation, given that the kind of work he's trying to get into is as a social support worker, then necessarily there is a huge concern for the safety of children. So it was certainly open to the DSS not to issue the license, and for that reason, this decision is unlikely to meet the standard of Wednesbury unreasonableness. So under the facts, I would advise Gordon not to apply for judicial review because the DSS decision is unlikely to meet the standard of Wednesbury unreasonableness. Now, what we need to remember again is that judicial review of administrative decisions, as a rule, is a very limited and narrow scope and examines the legality or lawfulness of administrative decisions. It does not review the factual correctness of administrative decisions. Under the facts, there is support. There is evidence for the decision. The evidence came in the form of a police investigation, even if it was subsequently terminated. It was also in the form of news about the child molestation. So are we clear? So in this particular instance, under the context, as a solicitor, I would advise Gordon not to apply for judicial review. Clear? Now, just to change it a bit, same facts, what I'm going to do now is to change it so that what had happened was that the only evidence, if you call it that DSS has about Gordon is that there was an anonymous phone call saying that Gordon had been the subject of police investigation. But there is no evidence of any police investigation, neither was the so-called child molestation ever in the news. So let me repeat, I'm just changing the facts a bit here because I want to connect it to another theme in a short while when we discuss this. I'm changing the facts a bit so that what had happened was that under the new facts, problem 2A, the only evidence, if you call it that DSS had in arriving at the decision not to grant the license was that they had received an anonymous phone call that Gordon had been the subject of a police investigation for child molestation in 2005. However, the DSS is not in possession of any evidence that there was in fact ever any police investigation, and the DSS has no evidence that it was ever covered in the news. So the only evidence they had is that anonymous phone call saying that Gordon had been the subject of child molestation. Now, if that were the factual scenario, what would you advise Gordon to do? To Emma, unreasonable, apply for review, apply. So that would be correct. Under the facts, if the only evidence relied upon would be by the DSS would be an anonymous phone call, in the first place, that does not amount to evidence. It has very limited probative value. It does not prove the claim of child molestation. It's an anonymous phone call. Okay? So in that case, the decision could be impugned. Both, one, because the decision meets the standards of Wednesbury and reasonableness, and secondly, the other ground for judicial review would be that the decision, there was no evidence to support the decision. So what I'm trying to highlight with the problem 2A example is that oftentimes there are multiple grounds that could be asserted on the basis of a common set of facts. So on the one hand, you can argue that there was no evidence, and because there was no evidence in arriving at a decision, therefore, the decision would meet the Wednesbury and reasonable standard. Now, from Gay, an investigation that doesn't lead to charges isn't much evidence to base a decision on either. That is true. I agree, Gay. So that's a very good point from Gay. An investigation that doesn't lead to charges isn't much evidence to base a decision on either. That's true. But I would argue that it would still be open to the DSS to consider the grave danger of child molestation having occurred because of the seriousness of the offense. Remember, what we're dealing here is somebody trying to become a social support worker who is dealing with kids. And it's a bit too dangerous for the DSS to assume that, it never happened. Just because, as we know, when witnesses don't come forward, an investigation could be dropped. It doesn't mean it didn't happen.
You have to consider why charges weren't laid too. You know, quite often there's a reason for charges not being laid, even though there is a complete police investigation and the police believe that they are, you know, that the complainant is correct.
That's right. That's true. And, you know, in the news now, we hear often of, you know, the actors in the US and I think some in Australia who claim that they have been raped. And oftentimes the police will not file a criminal complaint for rape simply because, you know, they feel like the threshold of evidence has not been met to lodge a criminal complaint and for a criminal prosecution for rape to be successful. It doesn't mean that rape did not happen. It only means that the prosecutors are not confident of winning.
And sometimes it's not even the police, it's the DPS.
That's true. That's true. So again, context matters here. Okay. Moving on.
This is probably, hey Manjo, it's Gay. I'm not on the side of the pedophile, by the way. I'm just trying to play the devil's advocate. And Grant, having a defence background, might know a little bit about this too, but in defence it's very easy for wives to make complaints about domestic violence and then for the serving member to have their service threatened and not be able to come in contact with weapons and all those sorts of things too. So like people can make vindictive complaints with the knowledge that it's going to impact on their career.
True. Absolutely. I agree. Now, what we just have to remember is that the High Court has been very clear that the threshold of meeting the standard of Wednesbury and reasonableness is actually quite high. There are very few instances when courts have actually quashed an administrative decision on the ground of Wednesbury and reasonableness. So let me repeat that for emphasis. In case of doubt, courts are unlikely to quash a decision on the ground of Wednesbury and reasonableness. It's easy to raise, but that particular ground is not always successful. Very few cases have actually succeeded in raising that particular ground. So, that is because of at least two reasons, apart from the cautionary warning given by the court. It is for two reasons. One is that judicial review is always of limited and narrow scope, and courts should refrain from trying to evaluate the, number one, evaluate the factual correctness of decisions. Two, courts cannot or should not or should avoid trying to second guess the exercise of discretion on the part of decision makers. So here, this involves the discretion on the part of the DSS to grant it or not. That's discretion. Courts in general will avoid reviewing the exercise of discretion. And thirdly, the courts have been very clear that for the Wednesbury and reasonable standard to be met, it must have been a decision that no sensible or no reasonable person could have arrived at. So that's a very high standard to make. Now, therefore, in other words, if it is possible to argue that it's open to a reasonable person to believe that given the context of somebody applying for a license as social support worker who will be dealing with children, and this person is working under a shadow of doubt of potentially having committed sexual molestation or child molestation in the past, it would be very easy to argue that it was certainly open to the DSS to deny the issuance of a license. So the lesson here is don't quickly, the first thing as a lawyer would have to think is that, it's a high standard. Don't just say that, don't quickly jump to the conclusion that it's easy to make out or plead an instance of Wednesbury and reasonableness, because the general rule is it's difficult to prove Wednesbury and reasonableness.
So Manjo, in exam context, if you're answering this question and suggesting that he should apply for judicial review, would you expect that we'll go into the discussion about that it's not necessarily that he might succeed because of the history of the courts in regards to judicial review. Sorry, can you turn it down, please, guys? Turn it down. Oh my God, is it that loud? Sorry. Do you get what I'm saying? So what I'm asking is, do you want us to go into talking about how likely it is he would succeed?
Okay, now.
In addition to suggesting that he may have a case to plead?
Okay, so let's be clear. When a question is asked, such as advise Gordon on whether or not he can apply for judicial review, ultimately, it also asks the question of how likely is an application for judicial review going to be favorable or successful. So it's not a question of ticking off boxes where you can say there is a ground that we can raise. You remember, you're acting as a lawyer. You're not going to be advising a client to, just because, the 5 jurisdictional elements are there for an application for judicial review to be present. You're not going to necessarily suggest that therefore that client of yours should apply for judicial review. You're actually also weighing the likelihood of such an application to be successful. So that's the ultimate test.
Okay, thanks.
So what is therefore very crucial, and I think it will be apparent when you look at the marking rubric, is that the application of the rules of the facts actually merits the heaviest weight as far as the marking is concerned, as far as the marks are concerned. Because how you argue the rule according to the facts is really more important than just stating what the rule is, especially because this is an open book. It will be an open books assessment. So it's easy for you to articulate what the rules are. And especially because I would have told you in advance what the key topics will be. So that's the easy part. But the argument, which leads to a conclusion, that is a bit more problematic and more complex. So you should be prepared to argue. So the task is not just to say, can he apply for judicial review? I think I should have actually reworded that better. But whether or not an application for judicial review is more likely than not to be successful. And in that case, that's the context of your advice. Okay. Problem 3. Can somebody read problem 3 for us? Problem 3.
I'll give it a go, Manjo, but if my family gets too raucous, I'll have to hand it over to somebody with a quiet background. The Security Workers Act requires anyone seeking to practice as a security worker in a Commonwealth department, agency or office to obtain a licence from the Australian Department of Social Services and to meet certain requirements relating to education and training qualifications, physical and moral fitness, and police and security clearances. Mitchell Smith applied for a security workers licence with the ADSS in compliance with the Security Workers Act. Upon review of his application, the ADSS came upon information that Smith had at one time been the subject of a criminal investigation for a child molestation in the UK while he was there to study for a university degree. The ADSS subsequently sent Smith a letter to inform him that unless he submitted evidence within 45 days or until the 3rd of August 2017 to show that he had been cleared in the criminal investigation and the reasons for such clearance, it would be inclined to reject his application. 5 days before the deadline given by the ADSS, Smith sent in a letter asking for an extension of 30 days within which to submit the documents required by the ADSS. On the 10th of August 2017, the ADSS sent Smith a letter rejecting his application on the ground that he failed to meet the requirement about police and security clearances. He's come to you as a solicitor for advice. What advice would you give him?
Thank you, Gay. What do you think? Very good from Grant. Grant got it. What do you think? Should he apply for judicial review? What advice would you give him? Apply. Grant, do you suppose you could pick up the mic and explain your answer for us?
in the case where he was within the time frame to supply and asked for, effectively an adjournment to supply information, the fact that the ADSS didn't give him that time goes down to reasonableness, and he should apply and use Immigration v. Lee as a precedent.
That's right. Did Grant just disappear? So that was the correct answer there. The proper case you should be citing here is actually, as pointed out by Grant, Minister for Immigration and Citizenship versus Lee, where, under the facts, there was a request on the part of the applicant applying for a protection visa to be given more time to produce documents. And the Migration Review Tribunal had simply said no, because you'd been given enough time. And the court found that decision was unreasonable or plainly unjust, because there was no reason why, the Regional Migration Tribunal could just have given the applicant for protection visa enough time to produce the documents. And the same thing would, in the same manner, apart from the fact that this would be an instance of Wednesbury unreasonableness, to have granted the application for more time to submit documents, this is also an instance where there might be a breach of the right to natural justice. Okay, and if you follow the case of Said versus Minister for Immigration and Citizenship, following the case of Kiowa versus West, in the typical case, every applicant should be given an opportunity to present evidence that would counter any adverse information that has been raised, which is credible, relevant, and significant. An opportunity should be given. So in this particular problem, there would be two grounds that you can cite. One is Wednesbury unreasonableness following Ministry for Immigration and Citizenship, because the decision of the ADSS not to give Smith the time to produce evidence would be an example of something of an evidence that it would be an example of the excesses of power that is unreasonable or plainly unjust or oppressive. And at the same time, it is likely to breach the right of Smith to natural justice following the case of Said versus Minister for Immigration and Citizenship. Clear? Should we backtrack to problem 2 a bit? And we're doing this because we're heading towards the final assessment. So maybe it's just a matter of review of natural, other topics here. Was there a breach of the principle of natural, based on problem 2 alone? Okay. Do you suppose that Gordon could argue that his right to natural justice was breached because, he was not given a license, and the basis of the evidence was just an anonymous phone call and some news reports. Do you suppose that there was a breach of the right to natural justice? We're looking at problem 2, not problem 2A earlier. Okay, just this problem, just the facts based on problem 2. Good.
What comes to mind for me is whether he had a right interest or legitimate expectation to be granted the license in the first place.
Very good. Okay, what's your answer to that, Monique?
I'm going to say no.
No, the answer would have been he has a legitimate expectation to be given a social support worker's license. Not that he has a right, but he has a legitimate expectation to be given one if he meets the requirements.
So in a question a couple of weeks ago, we talked about this topic, and it was in respect of a job application, I think. Right. And in that scenario, you said that the person did not have a legitimate expectation. Can you just explain the difference for me, please?
Yeah, there's a huge difference there, because as far as a license is concerned, we can see here that a person is, who actually has the qualifications, for him to get a job as a social support worker, he needs a license. It's like he has no choice. And so therefore, if the license is not given, he can't get a job as a social support worker, notwithstanding the fact that he has applied for a diploma for community services. So there is a legitimate expectation that he will be treated appropriately and fairly according to the law.
Yes, but he's failed to meet that expectation. He's failed to meet the requirements.
That's true. But remember, we make a distinction between the right to natural justice as opposed to the substantive question of whether or not it will be granted. Those are two different things. Okay, we're still dealing with the issue of whether or not does he have a right, does he have a legitimate expectation to, to be given a chance to be given a license under the Act. That's the bigger question. He certainly doesn't have a right, but he has a legitimate expectation that he should be treated, given an opportunity to be granted a license. Because without the license, he can't work. There is that legitimate expectation. The job application is different. You cannot have a legitimate expectation that you will be given a job. The license is different. Okay, because, can you see the scenario there?
So with a job, I guess, there's only generally one position. And then with a license, there's lots of them. So also, not 1 million people or 1,000 people could have a legitimate expectation to be given a job, but in terms of a license, there's kind of an unlimited number, I guess, in a sense, and so more people would have a legitimate expectation to be granted a license.
Yes, absolutely. So as far as the license is concerned, we all have assuming that we meet the minimum qualifications or the qualifications required by the law, we have a legitimate expectation to be granted a license. It almost becomes a right.
So Manjo, sorry, though, like with visa applications, that's different though, isn't it? Like you can't have a legitimate expectation that you're going to be granted a visa, but if your visa's being renewed, then you could. Is that?
No, actually, that's the example of Minister for Immigration and Citizenship versus Lee and a lot of other migration cases where the courts has been clear that there is a legitimate expectation for a person to be given an opportunity for the visa application to actually be processed according to the law. There maybe not a right, but there is a legitimate expectation. So that if there is an application for a visa, for example, and the decision maker does not provide the individual an opportunity to be heard, then in that particular case, the courts will say that there has been a breach of the rules of natural justice. Specific example, Said versus Minister for Immigration and Citizenship, Kiowa versus West. Now, remember that the principle about the principle of natural justice is actually of common law origin. So in other words, it is a principle that has been fashioned and developed by the courts. So in other words, that principle, because it is of common law origin, can be displaced by express formulation by the Parliament. So Parliament can expressly say that when somebody applies for a visitor visa, for example, then that person does not have a right to natural justice. It is open to the Parliament to do that. So if you go by the Migration Act of 1967 Commonwealth, it says there that applicants of visitor visa do not have the right to natural justice. But in other visa applications, for example, it is understood that because it has not been because the Parliament has not expressed an intention not to grant the right to natural justice, it is understood that applicants for most other visas, especially for work visa or a permanent visa or a protection visa, that they have a right to natural justice. Okay. We're clear?
Manjo, can I just ask another question on this in terms of natural justice? This may be splitting hairs, but is there a distinction to be made by a first-time license applier versus someone who has a license and is reapplying? Or is it just all one big legitimate expectation because it's a license to work that they're, I suppose, legitimate expectation that they get it?
Yeah, there is a huge distinction, mainly because once a person has had a license, then that license, it's almost like that person has a right already to the license, and for it to be revoked, automatically there is if a person has not been given an opportunity to be heard, then the right to natural justice has been breached. it's different when it comes to a first-time application. We discussed this in the context of the right to natural justice. So there is a distinction between somebody who has a license and that license is revoked. Automatically, the right to natural justice arises. Now, an applicant for a license, on the other hand, certainly does not have a right to a license. So therefore, the license may not be given. But he does have a legitimate expectation to be heard before, or a legitimate expectation that his application for license will be examined and treated fairly according to the law. There is that legitimate expectations. In other words, if the decision maker, therefore, without any valid reason, just does not grant the license, that would be a breach of the law. So a distinction could be made there. So that's right for Monique. The threshold to revoke a license is really high compared to just granting one. Okay. So we have a final question here, problem 4. Can somebody read that question for us? That's the final question.
Happy to, Manjo.
Thank you.
The Business Regulations and Control Act, Commonwealth, requires that before a person or persons may engage in business or commercial activity, prior registration must be secured from the Australian Business Regulatory Agency. The Act provides that the agency has the power to shut down a business or commercial activity that operates without being registered with it. In addition, the agency may also seize documents, papers, goods, properties and assets belonging to an unregistered business and impose a fine. The Act is silent on whether prior notice must be given by the agency before seizing the documents, papers, goods, properties and assets belonging to an unregistered business. Aaron Lamb has been operating a small business for some time by selling his handmade goods to customers online. However, he failed to register with the Australian Business Regulatory Agency. In February, representatives of the Australian Business Regulatory Agency came to his house without notice and seized his goods, documents and papers. They informed Lamb that his goods, documents and papers would only be returned after he paid a fine of $10,000. Lamb has come to you as a solicitor for advice. What advice would you give him?
Very good. Thank you. What do you think? What would your advice be? Apply for judicial review? And when you say apply for judicial review, you're actually saying that there is a good likelihood, a good chance that the application will be successful. Apply or not apply? What do the others think? The proper answer here would be that you should advise Lamb to apply for judicial review. And the pertinent cases would actually be Edelson versus Wilcox and Cooper versus Board of Works for the Wandsworth District, as well as Jarrett versus Commissioner of Police, because the general rule is that before a person can be deprived of his property, he should be given an opportunity to be heard. So that element involves the right to natural justice, which is related, very much related to the issue of Wednesbury and reasonableness. So in this particular instance, it could be argued that his properties, were arbitrarily seized by the ABRA. It should have been, before the ABRA seized his property, he should have been given an opportunity to explain why he was unable to secure a license, because there could have been a very innocuous or innocent. You are a bit quiet. Am I quiet? What does that mean? Are you hearing me or not?
You go really loud and then you go really soft. I don't know if it's my computer or whether it's on your end.
No, mine does it too.
So does mine.
Oh, okay. So it's probably my internet signal there. Okay, so there are 3 cases. I should probably just go closer. It's probably because it's the fan interfering with the sound. So if I were the lawyer, I would advise Lamb that he should apply for judicial review, because What is involved here is his right to property, which has been impaired by the decision of the ABRA to seize his goods, documents, and papers. So whilst it is true that it is within the power of the ABRA to actually seize his goods, this is still an instance of an arbitrary seizure where the law, because the power was there, has actually become an instrument of oppression. Following the case of Edelston versus Wilcox, the federal court said that when what is involved is the seizure of an individual's property, this is a decision that should not be taken lightly by administrative decision makers. And the individual whose rights to property are likely going to be affected should be given an opportunity to be heard. And if there is a less stringent, a less extreme action that could be undertaken by the executive, then that should be the one that should be preferred. So the particular case is Edelston versus Wilcox. And the second reason why I would advise Lamb to apply for judicial review would be that there's a breach of the rules of natural justice. Because before Lamb's goods were seized, he should have been given an opportunity to explain why he had failed to secure a license. If you remember the case of Cooper versus Board of Works for the Wandsworth District, the court there had said that there might be a very innocent or innocuous reason that would explain why somebody failed to acquire a license. It could be that he could have forgotten, he was about to apply for it, there could have been a delay and so on. And so therefore, under those circumstances, the better thing for the administrative decision maker to have done was to give the individual whose properties were to be affected an opportunity to be heard. Okay. That's it for tonight. Any questions or comments? Questions, comments? So we've covered the 5 questions tonight.
Excuse me, Manjo.
Yes, Yomi.
With this topic, it seems like we cross over to natural justice, and with other topic, we're specifically on the topic of the week when we answer the questions. Now, I'm going back to the quiz. So are we to answer the quiz accordingly as we deem fit, or are we restricted to Wednesbury unreasonableness and outer limits of legality when we're answering the quiz for this week?
Well, you will notice that when I phrase the potential answer to a quiz, I actually cite various topics. Sorry. So I wouldn't say that. Actually, I have 2 dogs. I wouldn't say that the answer necessarily revolves around Wednesbury unreasonableness. I may throw in a principle just to throw you off. Like, sometimes I would say that, it should just be merits review. So I can't say that when I give a quiz answer, it's just all about the topic. And especially because we're now moving towards the end of the term, what I've done is to start bringing you back to the other topics that we've discussed. So in the past, if the topic was on natural justice, I focused my discussion on natural justice. I did not discuss, law, fact, and evidence, nor did I discuss Wednesbury unreasonableness, because we hadn't discussed those. But because we're now at a point where we're now in week 9, I need to show to you that certain facts may actually lead to to different grounds for judicial review, and you need to be aware of these possible grounds. Because if you cite 2, 3, or 4 grounds, for example, in an application for judicial review, and you have some reasons for citing those grounds, one of those grounds may fail, but 2 or 3 others may actually succeed, and that's what you should be doing. So you should always be conscious. Now, remember, if you look at the ADJR Act, there are multiple grounds for judicial review. So you need to determine, is this decision potentially subject to judicial review on this ground or that ground or that ground and so on. So you need to be consciously aware. You need to be aware that there are various grounds available under the ADJR Act, and you need to be able to, to take off and determine which of these grounds you should be citing in an application for judicial review. Okay.
Thanks, Manjo. Just for clarification, thank you.
Questions, comments? We're good? Okay then. So I think we're good. I will post the answers to the 5 problems I gave tonight in Moodle, hopefully tomorrow, if not over the weekend. Okay, so don't forget the case notes assessment, which is due tomorrow at 11 p.m. Queensland time, as well as the presentation. I think a lot of you have already submitted those assignments. Well, good, but for the others who haven't, it's just a reminder. So thanks again for joining tonight's session, and when you get the chance, try to do the unit evaluation if you get a chance. Okay, thank you, and good night, and I'll see you next week. Bye.